Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti. Today's topic is Where Next? Climate Change, Sustainability, and EU Competition Law. Climate change is perhaps an existential issue for our planet. And as policymakers around the world grapple with how to reverse course on what could be a catastrophic path, we run into competition law issues. In the European Union, there has been a rather explicit discussion about how these issues may interact. We talked about something similar in episode 16, but related only to the United States. And today we're going to take a perspective from the European Union. My co-host today is Matthew Hall. Hi, Matthew.
Hi, John. It's good to be back.
Thanks, Matthew. So, Matthew, what are we doing today?
Well, as you just said, John, climate change is described often as an existential threat. It requires a response on various fronts. Competition or antitrust law is just one part of the legal framework, but that's what we're talking about today. So what we're going to be considering is competition law part of the problem in the response, or can it be part of the solution?
Who's our guest today?
Well, we're talking with Emma Cochrane from Linklaters here in London, the competition group. She's experienced in advising on all areas of EU and UK competition law, including cartels, mergers, market investigations, and general commercial agreements. And one of her particular interests is the relationship between competition law and environmental concerns. Hello, Emma.
Hi there. Thanks very much for having me.
Well, thanks for coming in. So if we just zoom back for a minute, looking at this at 30,000 feet or 5,000 meters or whatever we have, the EU somewhat sees itself as leading the way in the response to climate change, doesn't it?
I think that's right, yes. So, I mean, here in Europe, it really feels like we're in the middle of a big shift with climate change coming to the top of the public agenda. So around the world, we're seeing unprecedented weather events, fires, flooding, and we're also seeing massive political change. So, for example, the Extinction Rebellion events, vandalizing UK Cambridge colleges and so on. And I think also, the decisions that we're taking every day as individuals are starting to shift. I came here today with my reusable coffee cup. I brushed my teeth with a bamboo toothbrush and put a cloth nappy on my daughter this morning. So I think people's decisions are genuinely quite different to what they'd have been 12 to 18 months ago. And I think competition law hopefully has a role to play in that. So in December 2019, the European Union launched its Green Deal, which is a package of measures that together aims to make the European Union carbon neutral by the year 2050. And that's a hugely ambitious project, and it's got many different elements to that. So they're looking at decarbonising energy, supporting industry to reduce emissions, making buildings more environmentally friendly, and rolling out cleaner forms of transport. And within that, of course, the Directorate General for Competition has to come up with a policy and has to tackle the issues on the competition law side.
Well, thank you for that. Yeah, I saw that attack on Trinity College. I was unhappy about that. I attended Emmanuel myself, but still, it was not a nice incident. So backing up or maybe focusing in a bit further, that's the general background. So focusing on competition and antitrust law, there is the consumer welfare standard, which is the classic way of analyzing all types of competition law issues in the EU. So could you tell us a bit what that actually is and how this general background and flavor here in the EU is pushing on that in terms of the response to climate change?
Sure. So you're absolutely right that consumer welfare tends to be the standard that we look at in the EU as in the US. So we look at where we have anti-competitive agreements. We look at whether consumers will pay more as a result of that. When we look at mergers, we want to understand if prices are going to go up because two companies are coming together. But interestingly, if you go back to the underlying law, which in the EU are the treaties that establish the European Union, then you don't find that concept of consumer welfare really at all. What you actually do find in those treaties are statements that there is an overriding importance of environmental protection and sustainable development in Europe. So, for example, Article 11 says that environmental protection has to be integrated into the definition and the interpretation of all union policies. And so that, logically, I think it would include competition law.
Yeah, I mean, that's extremely interesting. I mean, consumer welfare standard is the gold standard. But as you say, looking at what the treaties actually tell us, the classic focus on economic welfare and prices isn't necessary. So what is that? What is the political response to that? And what is the competition commissioner saying, if anything, about that issue?
So, I mean, I think first and foremost, the competition team at the Commission is part of this broader effort within the overall Commission to deliver the Green Deal. So they are thinking carefully about how competition law can feed into their overriding objective of achieving this climate neutrality in 2050. And at the minute, I actually think they're in listening mode. So at the moment, they're consulting on a refresh of guidelines that they issue that sets out how they deal with agreements between competitors. And they're due to give some updated guidance on that, but not until 2022. And I think they're really, listening to what the competition community here in the EU is saying at the minute, which is building a head of pressure towards sort of some explicit guidance on these issues.
Okay, so listening mode. Let's dive into some specific areas. I think we're going to try to cover the classic issues of cooperation between competitors. What can competitors do to respond to climate change? We'll also look at state aid, which is probably leading the way in the EU in terms of the response. And also, hopefully, we'll have time to look at the impact on merger control, which is maybe a bit less developed than some of these other areas. So looking at cooperation agreements, so what we're talking about here is, of course, the issue that competitors may get together in many ways to whether a joint venture or any type of other arrangement. But at the same time, this can cause issues if it's not done appropriately. So what is the basic concern with competitors trying to get together in order to do things which might be suitable or helpful from an environmental point of view?
Sure. So, I mean, I think the basic concern is as competition lawyers, we tend to have concerns whenever you get competitors sat in a room talking to each other. So here in the EU, we have, I say here in the EU, of course.
No longer.
Sadly, we're not actually in the EU anymore here in the UK. But across Europe and also in member states, we have Article 101, which is the equivalent of the US Section 1 of the Sherman Act. It prohibits agreements which restrict or distort competition. And, competitors talking to each other tends to be a red flag. I think probably what is helpful to think about is why companies want to coordinate in the first place and in fact, why we might want them to. So first of all, I'd say some of the problems surrounding climate change are so big that one company acting on its own actually can't have that much of an impact. So it is in everybody's interest if companies can get together and benefit from economies of scale and scope and get together and really have an impact. The second reason that we might want them to coordinate is that a company acting alone simply might not take action. So, for example, if I'm a company that wants to switch to an environmentally friendly form of packaging, or switch my energy supplies to renewable sources, then that is likely to have an impact on my cost base and make my costs go up. Assuming that I'm already charging a competitive price, that has an impact on the prices that I can charge to my customers, and they'll go up as well. And if you, Matthew, are selling a competing product and don't make that environmentally friendly switch, then my customers might switch away from me to you. And overall, that means that everybody loses out, because my investment in the environmentally friendly packaging is lost. And so really, what we might do if we got together and agreed to together develop this packaging and switch to it is to eliminate the first mover penalty and spread the environmental benefits across the whole market.
But arguably, since we're competitors, there's a restriction of competition, hence the issue.
Exactly.
And what can we say, bearing in mind this overall existential threat? And also, I think part of the problem is we have to decide for ourselves, largely, whether there's a concern. So how might we justify these types of arrangements if, on the face of it, they are restrictive of competition?
So I think there's a few ways, and I probably don't have time to talk about all of them now. I'm going to focus on two. One of them is saying that actually your agreement doesn't restrict competition at all, and you fall outside Article 101. And the other one is an efficiencies defence, which is Article 101.3 under European law. There are some other ways around it, and for anybody who is really interested, I would hugely recommend an article written by Simon Holmes, who writes and speaks on this topic a lot, which goes into some of the other ways that you could get around this in some more detail.
We'll put that on the website, by the way.
So looking at that first one, sort of getting yourself outside of Article 101 altogether, EU competition law has got a number of safe harbour regulations, which we call block exemptions, and they say that if you can satisfy the requirements of the block exemption, there's no restriction of competition. So when you're entering into a sustainability agreement, you could, for example, try and characterise that as a research and development agreement. So, for example, in the packaging example, you could get together to research and develop a new type of packaging, and assuming that you fulfil the requirements of the block exemption, then that means that there's no restriction of competition at all. And more broadly, you can think of a number of different types of sort of sustainability agreements which actually wouldn't restrict competition on its face, but equally there are a number that will. And so for those that will, I think looking at the efficiencies defence under Article 101.3 is an option. And that basically says that if your agreement does restrict competition, as long as it results in a benefit and consumers are given a fair share of the resulting benefit, then there's no infringement, provided that there wasn't a less restrictive way of achieving your aim and that there's still some competition left, so that there's not an elimination of competition. But as you say, the problem with that is there's quite a lot of uncertainty around whether you benefit from the efficiency defence, and companies do have to make their own assessment of that. And we see on the ground that it can be off-putting, and there are sustainability initiatives out there that aren't going forward because of this level of uncertainty.
So do you think that's because lawyers are being too careful, or they're not looking back to the Article 11 in the treaty that you refer to, or the case law isn't there for them, or what is the problem largely with those examples?
So I think there is a bit of a patchwork of guidance at the minute. So there's conflicting cases going on. So, for example, there's a case back from the 1990s which related to washing machines. There, the Commission found that it was okay for washing machine producers to phase out old models and replace them with eco-friendly washing machines, and the customers there would get some benefit because they'd have lower energy costs, they'd use less soap. But the Commission there also gave weight to the fact that the environmental results for society as a whole would allow customers a share of the benefits, even if there wasn't a direct benefit to the purchaser of the washing machine.
So that's one of the parts of Article 101.3 that you were mentioning. It's one of the specific heads that's required in that. Exactly.
But then from that case in the 90s, we then look at some of the other guidelines around Article 101.3, and that they seem to actually rule out looking at that benefit to consumers more generally in favour of focusing on purchases of specific products. And we also see cases, for example, in the Netherlands, where arrangements to agree minimum welfare standards for chickens were found to have breached competition law because the improvements came at a higher cost than consumers were willing to pay, combined with the sort of quantifiable environmental benefits. So I do think there's a real patchwork, and, is it because lawyers are being too conservative? I mean, maybe there's some of that, but also, it's
you have to use the precedents, don't you?
You can only work with the law you've got, and companies can quite reasonably take the view that this is a risky area.
Yeah. Okay. So before we move on to state aid, I think you mentioned earlier the consultation going on with relation to the horizontal guidelines. These are very important guidelines on what companies can do, competing companies can do when they cooperate with each other. So do we have any indication of whether these guidelines are going to have a special section on, maybe on environmental issues, or maybe there'll even be a new block exemption, giving automatic exemption to some of these things? Do we have any idea, or do you have a view on what we should have?
I certainly have a view on what we should have, and you can probably guess what it is. I don't think we have a sense at the minute of what is going to be. And so the Commission's consultation on what people think should be included has closed, and we would expect there to have been, a number of responses saying that this type of agreement should be covered. Interestingly, the previous version of these guidelines, which was issued in 2002, actually had a section on sustainability agreements, which was removed. So it would be really great if the Commission would think about reinstating and updating. Exactly.
In an improved version in 2019 or 20 or whenever it happens.
But I mean, the other thing, of course, is that the horizontal guidelines won't actually be renewed until 2022. And so what would be great is some sort of statement from the European Commission, perhaps a statement of priorities or an indication that they wouldn't be minded to take enforcement action against a sustainability agreement, which would, whilst they work out the policy view on how competition law is going to respond, would just give companies some comfort and the ability to move forward in the meantime. Yeah,
okay. So some kind of interim guidance. I mean, I think, so moving on from cooperation agreements, I think, as you say, there's not much guidance out there, but maybe lawyers need to be a bit imaginative and try to push the bounds. It's difficult for clients to take that on board sometimes, and difficult for lawyers as well. Moving on to state aid. State aid is, of course, this slightly unusual regime in the EU under which essentially, in principle, any type of measure from the government or the state is banned unless it's on a pure market basis. But there are a large number of exemptions. So I think it's probably fair to say that state aid is kind of leading the way in the EU in terms of pushing environmental projects.
I think that's right. So state aid can be granted in the EU for environmental protection and energy objectives, and provided that it doesn't adversely affect trading conditions. And there's a very detailed guidance document that sets out the circumstances where you can grant aid. And there are numerous examples of state aid being granted to promote an environmental agenda. So just a few examples. Recently, there was aid to assist with establishing an electric car infrastructure in Romania, aid to retrofit diesel buses in Germany, aid to encourage investments in renewable energy in the Netherlands. The list really goes on. And in fact, 30% of the approvals in Q4 2019 related, at least in part, to environmental grounds. So it's, clearly an area where state aid is pushing the environmental agenda. And Commissioner Vestager credits the state aid rules with helping to bring down the cost of subsidies for renewable energy and in supporting the emissions trading systems.
So while cooperation agreements between competitors, I think you're saying, are really behind the curve, or it's difficult to do a lot of the things that companies would like and maybe should do, it sounds like in state aid, with governments being able to provide funds to the private sector, and a whole range of other measures, tax, etc. It sounds like you think that this is really in a good place. Or do we need some? Are we looking at some changes, or do we need some changes?
I mean, so there is reform afoot. I think we're expecting revamped guidelines on exactly when you can grant subsidies for environmental protections sometime later in 2020. And the Commission has said that it wants to finance the Green Deal by mobilising €1 trillion of sustainable investments over the next decade. And those plans include amending the state aid rules to sort of make it easier for governments to grant state aid to regions that are heavily dependent on traditional energy sources, helping them to transition to renewable energy sources, and also to incentivise investments by the private sector into eligible environmental projects.
So there's a direct link here really with EU industrial policy. We've heard a lot about EU industrial policy, haven't we, with the French and German governments saying that, and I think there's something coming out from the Commission maybe as well, that there should be a focus on particular sectors. So here, state aid is, i.e. government funds and other measures, is probably going to work quite well in the environmental sphere with industrial policy generally, I think.
I think that's right. And I think what would be really nice is if the Commission could kind of look at the whole and bring it together, so you bring the coordination side and the merger control side up to the same level as state aid.
Right. Okay. So we mentioned merger control. I think obviously merger control is not really such a day-to-day issue for businesses. The cooperation agreements between competitors, what you can do when you talk to your competitors, whether it may be in relation to washing machine changes or what have you, and also getting funds from the government are specific topics. But merger control is not something you do every day as a company, of course. Yeah, and I think we said in the introduction that we're maybe in the foothills, if you like, of how environmental issues are taken into account in the merger control field. Would you agree with that? Or are we much further down the line than that?
I mean, I think you're right that we are still in the foothills, but I think we're definitely starting to see it happening. So, I think what we do see is that environmental considerations are starting to drive the M&A agenda of companies. So, for example, you've got BlackRock telling us that climate change is an existential threat to markets and saying that they're going to sort of massively reduce their exposure to fossil fuels and increase their exposure to sustainable investments. And you've got Cambridge University again getting into trouble about having an endowment fund heavily reliant on fossil fuels. So I think, we are seeing environmental considerations driving M&A strategy in companies and ultimately deal valuation. And there's very much a mixed picture with how authorities are looking at these issues.
So looking at that issue, so that I think you're right. There's a wider issue in terms of what companies are doing and what their investors are telling them to do. But if you look at the legal nitty-gritty of I'm doing a deal, I think this is going to be positive for the environment. That might be one of my arguments. Or the regulator might look at it and think, oh, this is actually going to be bad for the environment. So what are some of the legal, what's some of the legal analysis here that we need to go through and we need to get past, if you like, in the merger control side?
So, I mean, I think if you're looking at a transaction where you've potentially got harmful environmental effects, then you can expect more scrutiny from the regulators at the minute. So there was a recent deal in the EU, Arubis Metallo, relating to scrap copper, where the fact that a significant portion of their customers could potentially use the product for manufacturing batteries for electric cars was part of the reason it got pushed into the phase 2 in-depth review. The flip side of that is that there's a transaction in Germany called Meerbit-Solin that actually went the other way. It was waved through despite considerable competition problems on the basis that it was so good for the environment that it outweighed the competition concerns.
That was a slightly strange case, wasn't it? Because I think the Federal Cartel Office, or the Bundeskartellamt, so the basic competition regulator in Germany, actually blocked it.
Correct, yeah.
But then the minister said, oh, well, I think we need to clear this on environmental grounds.
Exactly.
If I'm arguing at that first level, if you like, before the regulator, am I able to argue either that, this is good and therefore you should clear it on the basic consumer welfare, perhaps expanded test, or there's some kind of efficiencies argument we can bring, like similar to 1013 that you're mentioning? Is that how we could argue it at the first stage?
I think there's a bit of both. So I think at the kind of first stage, the advice to clients is if you have a clean deal, get that up front, make sure your underlying documents support that, and really talk to the Commission about deal rationale and why you're doing the deal. You can also bring these arguments in on the efficiency side, although regulators do tend to be a bit more skeptical of an efficiencies defence. But I think the key message is get it in wherever you can and see where it takes you, because there's not a clear practice at the minute.
Emma, if you were to look into your crystal ball and try to predict where things are going to be in this area over the next 3 to 5 years, what developments do you see?
So I think I could see the Commission bringing in this expanded idea of consumer welfare and giving us some clearer guidance on how you go about quantifying that, but kind of keeping it within a reasonably traditional view of competition law, looking at consumer welfare, looking at an economic analysis of transactions and behaviour, so that you don't completely throw the competition rule book out the window and start making decisions on transactions or conduct because of the environmental impact or otherwise.
And my other question is this a little bit of a slippery slope? So we say to ourselves, climate change is really important. So let's make sure that competition law doesn't stand in the way. But couldn't we equally say gender equality is very important? We should make sure that we take that into account when we think about competition law, or economic equality or economic injustice is important. Where is there a slippery slope problem? Do we worry about this, or is climate change different?
So I think you could say that climate change is different because it's an existential threat to the world as we know it. So that's one way that you could do it. I think the other way that you could do it, though, is say there's a genuine economic impact of climate change, and we can quantify that, with carbon trading and so on. And so we just need to be a bit more sort of wide-reaching when we build these economic models to factor in not just a sort of short-term look at the price of a good to a particular consumer, but the economic cost to society.
Yeah, I think that's a very good point. The chicken of tomorrow case you mentioned from the Netherlands, actually, although it was blocked by the regulator, the arrangements there, they did carry out a model, didn't they, to try to calculate what the benefits would be from an environmental point of view in that case.
They did, and it's a really interesting case, and kind of a shame that was the results at the end of the day. And I think there's all sorts of things that you could look at with that model and question whether they could have done it a slightly different way.
Yeah.
Emma, let's shift gears a little bit. I want to ask you, you really enjoy practicing competition law. Why? What's fun about that?
So I think the most fun thing about it is that it changes all the time. So this conversation about sustainability we would not have been having 2 years ago. All the really interesting stuff about big tech that we talk about, that really wasn't happening 5 years ago. I think competition law is so embedded in the markets that we kind of see, and the political developments, which means that it's always new and it's always fresh.
And if you could go back in your time machine to meet the 22-year-old you, and you could give you some advice, what would you tell you?
22-year-old me, I would tell me to do a slightly longer gap year. There's a lot of time to work, so go and travel and see the world while you can.
Did you take a gap? Did you yourself take a gap year?
I did, but we traveled only for about 4 months, and I think I could have traveled for a year and 4 months.
All right, and then last question before we get to the next segment. Emma, tell us something about yourself that is interesting or unusual that we wouldn't know if we only knew you professionally.
So I am a keen orienteer, and most people will not know what orienteering is, so I will explain that, or at least their view of orienteering will come from their PE lessons when they were 12 years old. So orienteering involves an individual running race, generally in as remote a piece of forest as you can find, where you get a map, you navigate yourself around a series of checkpoints, registering with your electronic dibber as fast as you possibly can. And it's great fun. Thinking about where you're going and trying not to get lost means that you don't think too hard about how hard you're running and how tired you are.
Do they ever spin you around 3 times before send you off on the orienteering?
They don't need to because it's so confusing anyway.
All right. Well, then let's go to our final segment, which we call the Curious Hat.
And now it's time for the Curious Hat.
In my hand, I have a set of questions that we've written in advance, and they are numbered from 1 to 20. And Emma, I'm going to ask you to pick a number, and I will read you the questions associated with that number.
I will take number 8, please.
All right. Number 8. Okay, this is an easy one. Do you currently have any pets?
I do. I have a new cat. He's called Jet. He is a black cat. He's 11 years old, and he came to live with us about a month ago because his previous family, the dad there, developed really bad breathing problems. They thought he had heart failure, and then it sadly turned out that he was allergic to the cat. So the cat was relocated and came to live with us.
Have you ever thought of upgrading to a sort of a more exotic cat pet, a lion, a jaguar, tiger, anything like that?
I'd love a Bengal, but I think tiger might view my kids as a snack. So I'm going to stick with Jet for now.
Okay, and with that, that brings us to the end of an episode. Thank you very much, and we will see you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.